So good morning, good afternoon, and good evening to everyone around the world. I am Victoria Sahani, Associate Dean of Faculty Development and Professor of Law here at the Arizona State University Sandra Day O'Connor College of Law. On behalf of ASU Law, I am positively delighted to welcome you to the 2022 John P. Morris Memorial Lecture. This is the second time that we are presenting this lecture virtually, and we want to thank everyone in the audience for joining us for this event, as we have a total audience of over 150 registrants. John P. Morris was the first and for a long time the only African-American faculty member at ASU Law. He had a lasting impact on those who knew him, and this annual lecture series was established in his honor to honor his memory. The topic of each lecture relates in some way to the legal issues surrounding diversity and inclusion today. The lecture provides an invaluable opportunity for our students, faculty, staff, and the general public to learn more about the work being done across the country and the world to address inequality and injustice. I would like to take a few minutes to thank everyone on our staff who has worked hard to make this event a success, including Jay Jenkins, Austin Prutch, Karen Sung, Bari Barnes, Julie Tenney, Sam Williams, Kathy Oleg, Anna Maldonado, Mary Hess, Gabriel Velez, and Sam Williams. I would also like to thank our speakers, Robin Morris-Collin, Professor Robin Morris-Collin, Professor Josh Sellers, and our John P. Morris Memorial Lecturer, Mr. Damon Hewitt, President and Executive Director of the Lawyers Committee for Civil Rights Under Law. Thank you all so much for making time to join us and to share your remarks. I would now like to introduce the daughter of John P. Morris and the Senior Advisor to the Administrator for Environmental Justice at the Environmental Protection Agency, Ms. Robin Morris-Collin, who will tell us more about her father and the importance of this lecture.
Thank you so much, Victoria, and thank you to the ASU faculty for this wonderful memorial of my father, who was a founding member of the ASU Law faculty. He was also an entrepreneur. He founded the first and the only ocean-going vessel line owned by African-American people, an African-American family. For those of you who know, Marcus Garvey chartered his vessels, and we were owners. He was a lawyer for the challenges of integration and civil rights. He integrated the practice of law in the city of Chicago. He integrated the Chicago hospital system. He built affordable housing in Tempe. He was also a beloved counselor to many of the faculty at ASU. I remember the long lines outside of his office of faculty and students who were waiting to get in to see him and talk to him. He was also a friend and mentor, beloved mentor for many of the athletes at Arizona State. And one of his dearest friends was Joe Caldwell, who I hope is in the audience and a beloved member of the ASU family. For those of you who are in the audience who still remember him, you will remember his joyous spirit and his absolutely infectious smile. And I still remind myself that if people didn't have the experience of sitting in his presence and being inspired and lifted by that smile, that we have a duty. We now have a duty to make sure that that joyous spirit and that infectious smile live on. So for those of us who may be finding it hard to be joyous and inspirational, take the challenge, do it, because we need that more than ever. And I'm so grateful to hear the words of our speaker, Mr. Hewitt, today, because I think of the promise of democracy as part of that joyous struggle as we reach a multiracial, multi-ethnic nation. How will we govern ourselves in democracy? So thank you so very much for inviting me and allowing me to introduce my father and to be part of this occasion. Thank you.
Well, thank you so much, Professor Collin, for sharing your father's inspirational story. I know I speak for many of us when we say we're honored to follow in his legacy and are grateful that you could join us today. So it's my distinguished pleasure to introduce today's speaker, Mr. Damon Hewitt, who is the current president and executive director of the Lawyers Committee for Civil Rights Under Law. Throughout his distinguished career, Mr. Hewitt has worked as a civil rights lawyer, a social justice strategist, a philanthropist, a coalition builder, and more. Before joining the Lawyers Committee, he served as inaugural executive director of the Executives Alliance for Boys and Men of Color. And prior to that, he served as senior advisor at the Open Society Foundation, where he coordinated funding efforts in response to the uprising in Ferguson, Missouri. Before entering philanthropy, Mr. Hewitt worked for over a decade as an attorney at the NAACP Legal Defense and Educational Fund, where he was lead counsel on litigation and policy matters. He also served as executive director of the New York State Task Force on police shootings, which was an initiative that analyzed the shooting of Black and Latino police officers by fellow officers who mistook them for criminal suspects. Mr. Hewitt holds degrees from Louisiana State University and the University of Pennsylvania Law School, and is the co-author of the book, The School to Prison Pipeline: Structuring Legal Reform. So the format for today is that Mr. Hewitt is going to speak for roughly 25 minutes, after which I will moderate a brief question and answer session. So if you have questions, please enter them via the Q&A function, and time permitting, we'll do our best to get through all of them. So with that, again, honored to introduce Mr. Damon Hewitt, and I turn it over to you.
Thank you so much, Professor Sellers. Thank you, Professor Victoria Sahani, Dean Sylvester, all the faculty and staff, and the students who are responsible for putting on this event, and also for carrying on the legacy of your namesake, Professor John P. Morris. Hello also to Robert Morris Collin, Professor Robert Morris Collin, and thank you so much for your words as well. Just want to say a quick word about these types of events and commemorations, or some call them memorials. They are so important, and every campus should have one. At my law school alma mater, University of Pennsylvania Law School, we have an event, we call it the Sadie Conference, named in honor of Sadie Tanner Moser Alexander, who was the first Black woman to graduate from the law school. Also the first Black woman to receive a PhD in economics, also from Penn as well. And it's always an amazing gathering. I actually gave that lecture in person this year, and I can't wait, remotely, excuse me, can't wait till we can be together in person again. And I'd love to join you even as a guest in person at your law school as well in Arizona. But it's important that you hold these events and continue to uphold the legacy, because whether you're talking about the first Black student or the first and for a while the only Black professor, there's always going to be a first. But the reason why we uphold the legacy is so that there will never be a last, that we always remember where we came from, and that we forge and blaze a trail going forward and keep that legacy alive, not just in memory, but in a living, breathing way. And that, my friends, connects to the theme of this year's conversation, I'll call it. It's about making the promises of our democracy real. To talk about that theme, I'm going to give you a little bit of background on the Lawyers Committee, and I think you'll hopefully see the relevance. The Lawyers Committee was founded at the behest of President John F. Kennedy in 1963, at the height of the Civil Rights Movement. He brought 244 of the nation's leading attorneys from the private bar into the White House to get them enrolled, get them aroused, and get them focused on the mission of protecting and defending the civil rights of Black Americans over whom both law enforcement, private citizens, private clubs were running roughshod on a daily basis. People living in fear of their lives, people living in fear of not being able to make a living at all, people who were cut off from opportunity at every pass. Now, I like to think of the founding of the Lawyers Committee as more than figuring out how a bunch of lawyers from fancy law firms can do a little bit of hours of charity here and there. Some people call it charity, but we call it pro bono work. But I think bringing those lawyers together, in my view, was an implicit political project that was more subversive than some people really appreciated, in at least a few ways. First, President Kennedy and the founders were making the bet that lawyers from the nation's leading law firms could actually function as what we call private attorneys general. Now, remember, President Kennedy's brother, Robert Kennedy, was the Attorney General of the United States, but he knew that even he was insufficient for the task at hand without more, that we needed to mobilize private attorneys general throughout the country to take up the cause of civil rights. I believe that the gathering of those lawyers was also about redefining what it means to be an elite lawyer, that you could be at the top of your profession, but are you making your fullest and highest contribution if you're not also contributing to the great issues of our day? Back then, it was racial justice, and today it's racial justice as well, aligned with so many other movements that are under threat and under attack, but also mobilizing. And then finally, I think this was an implicit and subversive political project because those 244 lawyers were not a monolith. There wasn't only white male lawyers in the room. There were plenty of them, obviously, but there were also Black people in the room, including Sadie Tanner Moselle Alexander, including Ernest Dutch Morial, who was the first Black mayor of my hometown, New Orleans. They were in the room as well. And so it was an integrated group, which in 1963 was very notable for its time. And fast forward 60 years, we're a multiracial organization at the Lawyers Committee. And so just as you heard just a few minutes ago from Professor Robin Morris Collin, this notion of having a multiracial movement, a multiracial effort, and intergenerational at that is critical to who we are as an organization, to who we are as a movement, and to how you can connect and contribute as well, which I think we'll talk about a bit later. Now, 1963, when our organization was founded, was widely regarded as a defining year of the civil rights movement. You had George Wallace, governor of Alabama, standing in the schoolhouse door to stop two Black students, Vivian Malone and James Hood, from entering. The standoff that ended only when President Kennedy sent National Guard troops to the campus. The same day, you had the nation's first televised speech about civil rights, again by President Kennedy. He asked Congress to enact legislation protecting all Americans' voting rights, their legal standing, educational opportunities, access to public facilities, and the like. You also sadly had, just within hours of that, in the wee hours of the next morning, NAACP Mississippi Field Secretary Medgar Evers assassinated in Jackson, Mississippi by a white supremacist. Later that summer, later that month, in fact, the Lawyers Committee was founded on June 21st. So this was the context when we were founded. And of course, just a couple of months later, the March on Washington in August of 1963. And then, of course, President Kennedy himself was assassinated later that year. So this was a serious moment. And I think we're at another serious moment as well in this country. And I think there's also a silver lining of sorts, which I'll talk about a little bit later. But the seriousness of this moment is really, I think, traced in the fact that so many of the gains of the civil rights movement are under threat and are being eroded. The seriousness of this moment is underscored by the fact that even after all of the righteous and multiracial protests, the legions hitting the streets in protest after the killings of George Floyd, Breonna Taylor, and others, and even Trayvon Martin and Ahmaud Arbery, that Black people are still being killed by state violence, by local law enforcement, and also still being killed by interpersonal violence and hate-motivated violence as well by white supremacists, self-avowed white supremacists. So we're still seeing these things. And think about those events of 1963. When George Wallace stood in the schoolhouse door, that was an elected official engaged in massive obstruction of justice. When you had to have President Kennedy deliver his address on the importance of civil rights protections, President Biden has had to do the same thing to try to secure a way to strengthen the Voting Rights Act of 1965, which has been eroded by the Supreme Court, which I'll talk about in a bit. When we talk about activists having their lives and liberty at stake and on the line, think about the mysterious deaths of so many of the protesters who were on the front lines in Ferguson, the revelations that so many Black activists have been profiled and monitored by federal law enforcement. These things are all very disturbing. So in some ways, everything old feels new again. In some ways, it feels like we're waging the same battles again, or maybe the battles never stopped. The threats to racial justice progress that we face today, my friends, are persistent and they're alarming. There are vicious attacks coming from every front. I've named a few, but there's ballot access, attacks on historical truth and accuracy in K-12 curriculum under the guise of challenging critical race theory, when we know that so much of what is being taught in schools isn't even critical race theory at all. We'd love to talk about that later. Attacks on women's reproductive rights and also diversity in higher education. And of course, we also saw the violent physical attacks at the nation's capital on January 6th of 2021 in an effort to subvert the ballot results of the presidential election. But amidst these horrors, I do believe, and I hope and I pray that there's coming a new awakening, because I believe that Americans from all walks of life are realizing that something connects all of these kinds of incidents, and it's racism. And that includes the January 6th attacks, because if you think about it, it was Giuliani and Trump and Roger Stone who were saying that there was something fishy about election results in major cities like Atlanta and Detroit and Milwaukee, cities that have large populations of people of color. They didn't talk about Des Moines, Iowa, or somewhere in South Dakota. They focused on where people of color voted en masse and where they lived and loved and played en masse. And it's really an inherently racist attack. At the Lawyers Committee, we represent 8 Capitol Police officers who stood on the front lines that day. Some of them were physically attacked. All of them were emotionally assaulted, at the very least, with lasting repercussions. Most of our clients happen to be Black men, just regular folks from DC or the DMV region who were doing their jobs and who were knowingly or not standing up for democracy at the same time. And that's why we've sued President Trump, former President Trump, Roger Stone, and a couple of dozen of their cronies, organizations, and individuals for their role in perpetrating their attack, because their attack was a racially motivated, we believe, attack on democracy itself. And we believe that that's what democracy, or racism rather, can cost us. It can cost us our health in terms of disparate health consequences. We've seen that in the COVID pandemic, where I lost my own father to the pandemic before vaccines were available. We see it in terms of wealth, where despite record lows in unemployment, the Black community continues to be underemployed at a significant rate. We see that racism can cost us our lives in terms of police violence and interpersonal private racist hate violence. And we also saw on January 6th of 2021 that racism can actually cost us our entire democracy if we let it. And this is why, when as lawyers, as advocates, as law professors, as elected officials, when we talk about the ideals of our Constitution and the ideals of democracy and the notion of equal justice for all, equal justice under law, it feels hollow to a lot of people. It feels like these promises of democracy are elusive. And they feel that way because they're not tangible. They're just words on paper that don't mirror or not reflected in the lived experience of so many Americans, especially Black Americans, who are our core constituency at the Lawyers Committee. And so part of our aim at the Lawyers Committee is to actually take these promises of democracy and make them real, make them tangible. So we're staying true to our historic mission, of course, at the Lawyers Committee, but we're also embracing and investing in a new vision of racial justice and equity that fights not just to stop bad things from happening, but also fights to build the just future that Black people and other people of color deserve, one that all Americans deserve. We use legal advocacy inside and outside of the courts to do this, and we believe that if we can bring tangibles in terms of greater power, expanded opportunity, amplified voice, and also changes to the material condition of Black people and other people of color, we can start to make the promises of our democracy real again. So I want to talk about some of the context in which democracy is under attack, and voting rights obviously is chief among them. So I started my work on voting rights the way I enter it today, with a simple premise that is factually correct. Think about this. So long as there have been elections in this country, there has been racial discrimination in voting. Every day, every year, every decade, there's been racial discrimination in voting. We've seen this time and time again. I'm not saying that every election result is so tainted that it can't be relied upon. I'm not saying that, but I am saying that there's racial discrimination in voting, because we continue to file and we often win these cases, as do our colleagues at other organizations, challenging things like racial gerrymandering in the redistricting context, challenging efforts to stop people from being able to vote. In fact, so many of the laws that we've seen come up lately are designed explicitly to make it harder for certain people to vote. What's worse, they're willing to make it harder for everyone to vote to get there. It's anti-democratic, certainly counter-majoritarian at base. And so when we think about these laws and what they're doing to our country, they're actually eroding democracy in a significant way. Now, we've long thought of the federal courts. We have this kind of nostalgia about the federal courts being kind of the great bulwark against violations of civil rights. But the sad truth is that for most of their history, the federal courts have actually not been friendly to civil rights claims. So I think about that when I think about the hostility that many of the federal courts now have, at least the appellate courts, to many of our claims, even as we win in the district court level, as we go on appeal, especially up to the US Supreme Court, it is for certainly tough sledding. Professor Nicholas Bowie observed the following. He wrote that as a matter of historical practice, the court has wielded an anti-democratic influence on American law. One has undermined federal attempts to eliminate hierarchies of race, wealth, and status. Think about this. During the Jim Crow era, between the end of Reconstruction and the passage of the Voting Rights Act in 1965, the Supreme Court issued devastating rulings that curtailed ballot access for Black people. Among other things, the court held that Black people had no federal right to vote, found that poll taxes, literacy tests targeting Black voters did not violate the Constitution because they weren't explicitly limited to one race. Also found that property ownership requirements could be used to limit ballot access, and also that political parties could limit access based on race because they were quote unquote private entities and not governmental actors. Now, of course, modern conceptions of the Equal Protection Clause in the Constitution, of course, and the Voting Rights Act of 1965 were game changers, right? In some ways, an antidote to some extent to many of these tactics. And it worked. Within a few short years after the passage of the VRA, the Voting Rights Act, the percentage of Black people who were registered to vote tripled nationwide. In the years since, Black political power grew through the creation of electoral districts that enable Black people to elect their candidates of choice. And quite often those were Black elected officials, but not always. But the judiciary is, of course, in the last at least decade involved in rolling back so many of those gains. I won't recite all of the cases in terms of their holdings, but think about Crawford v. Marion County Board of Election Board in 2008, allowing photo ID requirements to remain despite the disproportionate impact on voters of color. The infamous ruling in Shelby County versus Holder in 2013, which gutted the heart of the Voting Rights Act by striking down the formula used to require jurisdictions that had a proven and documented history of racial discrimination. It struck down a formula that required those jurisdictions to get pre-clearance or prior approval for all of their voting changes. And just more recently, last summer in Brnovich versus Democratic National Committee, that comes to us from the state of Arizona, the court allowed to stand so-called time, place, and manner restrictions in vote denial cases. And in doing so, created a whole new standard out of whole cloth that essentially gives hyper-partisan state legislatures a free pass to assert thinly veiled excuses such as alleged voter fraud to impose a number of restrictions on access to the ballot. And the court is poised to do more damage on Section 2 in the next term, where the case coming out of Alabama. There was even a negative ruling from a district court in Arkansas holding that there was no private right of action for private individuals to sue under Section 2, meaning that only the federal government could file suit. That hasn't gained any traction just yet, but it's just a dastardly ruling. So what difference does all of this make? Is it just a pitched battle between Democrats and Republicans? Is it just political stuff that doesn't matter to your everyday lived experience or those of your families? I think it would be wrong to think those things. First, there are doctrinal changes, but there are also big narrative changes that I want to underscore in this voting rights work. One is that the courts are pivoting away from older notions of saying that there is no discrimination at all to saying something that is much more insidious, that, well, yes, of course there's discrimination. In fact, Chief Justice Roberts wrote in his opinion in Shelby County that voting discrimination still exists. No one doubts that. So he starts with that as a baseline. But in that case, and also in the Brnovich case from last year, the court essentially has said, well, discrimination is out there, but we don't see it here. It's almost as if they're putting on blinders. Discrimination is out there, but you can't find it anywhere. In fact, you can't find it in the daytime with a flashlight. It's that hard to find, right? Now, immediately following the Shelby County ruling in 2013, we saw so many anti-democratic bills come forth, and we've seen even more just in the last couple of years after the results of the 2020 election. Again, laws that are designed to make it harder for Black and brown communities to cast their ballot by shortening polling hours, by eliminating drop boxes, by making absentee voting and mail-in voting much more difficult, by imposing tricky verification requirements designed to reject as many ballots as possible, especially from certain communities. We're seeing this in Georgia, we're seeing this in Texas, and Florida, and elsewhere. At the Lawyers Committee, we filed suit in federal court in Georgia and in state court in Texas. In both instances, we're saying that these states are at war with themselves and their own people, hurting their own people and undermining democracy just for political gain. We're seeing these laws and others that are leveraging the big lie about the 2020 presidential election being allegedly stolen, which is really, again, just a euphemism for racist allegations about voter fraud, thinly veiled but still apparent. We're seeing laws that are designed, like in Georgia, to entirely take over democratic infrastructure and political processes. We've seen the purges of a number of election officials, including Black elected election officials in Georgia, those local election boards that have so much power and the say-so over where polling places exist, what the hours are, and what have you. Those are being taken over at a rapid clip. Now, without the prophylactic power of Section 5 to stop bad things from happening through the pre-clearance provision, and with the erosion of Section 2 of the Voting Rights Act, what we're left with is essentially being boxed into alleging intentional racial discrimination. Now, I love a good intent claim because it allows you to tell a story about what's happening. Because when you try to prove intent, often on circumstantial evidence using the Arlington Heights standards or other factors, what you're doing is telling a story and asking the implicit question, if not the explicit question, why is this happening? And of course, in the case of Georgia, Texas, and other states, the why is because Black and brown people showed out to vote in amazing numbers in 2020. And they voted by any means necessary, by all means that were available to them. And it is those very means that are now being cut off and curtailed. So while these will be tough legal standards to overcome, we welcome the fight in these states because we think there's an important story to tell. I also want to make clear that it's not just government action that's been problematic when it comes to voting rights. It is also interpersonal and private action. We litigated a case on behalf of the National Coalition on Black Civic Participation in 2020, continuing into 2021, where we filed suit against individuals who set up thousands of robocalls, those automated calls that go out to phones. It used to be landlines, now cell phones as well, that were targeted to Black voters. And it told the voters three things: that if you vote by mail, the information that you use and submit will be used against you to track you down, to enforce outstanding court warrants and arrest warrants. That the information will be used to collect outstanding debts from your creditors. And also that the information will be used to force mandatory vaccinations. Now, you think about all of the pressure points that this was trying to hit, fears about police violence and mass incarceration, fears about economic insecurity, and fears about things that harken back to the infamous Tuskegee experiment. All of these points designed to have a chilling effect on Black people trying to vote. This was not a government doing this. These were private individuals who were emboldened by this atmosphere of polarization, emboldened, frankly, by the courts essentially saying anything goes, that all of these things that are happening aren't discrimination, right? And so this is the kind of environment that's being bred. We also see it in what we call the fraud squad, the efforts to engage in the so-called audit votes, these sham audits like we saw in Arizona as well. And of course, the Arizona effort bore no fruit for those who were involved. In fact, it actually underscored the result that the results of the election were in fact valid by an even larger margin, if I recall correctly. But these kind of efforts were copycatted in other states, and people raised a lot of money from it. And it stirred people up in ways that provoked their anxieties and fears on these false claims of fraud. So essentially what we're seeing here what this legislation, what these kind of efforts to undermine the valid results of elections is really like a modern day form of massive resistance. And if the term is familiar, it should be, because that's what happened after the Supreme Court's decision in Brown v. Board in 1954 and Brown 2 in 55. You saw all of these private efforts and sometimes government involved and sponsored efforts to prevent school integration and desegregation. And in some jurisdictions, including in places like Virginia, the decision of the local authorities was to shut down the schools altogether, to just basically burn the whole thing down to get your way. That's the equivalent of what we're seeing with respect to democracy these days. People willing to undermine all democratic process, all reason, all infrastructure in order just to get their way. So it is scary. There's another part of the narrative that is worrisome to me as well. This notion that if something is political or partisan, that it's not really discriminatory. Part of this comes from the Supreme Court as well. In its decision a few years ago in Common Cause v. Rucco, the court held that political gerrymandering is constitutional under federal law, that there's no problem, even though some states do prohibit political gerrymandering. But from my experience, what I'm seeing, having worked on some redistricting matters, is that there really is a very thin line, if any line at all, between political gerrymandering and its evil twin, racial gerrymandering. In fact, I tend to call it political-racial gerrymandering because it's often one and the same. And it's not just partisan. We have seen in Illinois, for example, where we filed suit that was ultimately unsuccessful, challenging what happened there, which was that the Democrat-controlled state legislature decided to protect its incumbent members in the state legislature. And it protected 3 white incumbents, but it did so on the backs of the Black community in East St. Louis. And that example, even though it was a loss for us, is one that's very important. And I've discussed this with the DNC, and we'll discuss it with anyone who will listen, that when you have a false equivalence between the interests of a political party and the interests of Black voters, it actually fuels that notion that it's just pure politics, that anything goes. Anything can't go, once again, when it's on the backs of Black and brown voters. That is racial discrimination we continue to maintain. Now, I think that despite all of these challenges that we're seeing to democracy, I have not lost hope personally, and for a few reasons. One, I think the stakes are not lost on Americans. There's been some recent polling that confirms that. On the 1-year anniversary of the violent Capitol insurrection, an NPR-sponsored poll found that 64% of Americans believe that democracy is in crisis and at risk of failing. People understand that something massive is going wrong. Now, the reasons people believe this may vary, but the inescapable truth is that they do understand that voter suppression and election subversion are not just undermining democracy, they're really destroying the very foundation of this nation. A second reason I'm hopeful is that, consistent with some of these widely held concerns, there seems to be at least one place where courts have started to draw the line, and that's with some of the election subversion efforts. At the Lawyers Committee, we were involved in over 50 voter rights cases in 2020, going into early 2021. 15 of those were post-election efforts to overturn results. Now, the courts have been pretty uniformly opposed to such efforts, dismissing these frivolous lawsuits. That's a win for the rule of law, and also the idea of a fair and independent judiciary. So at least they're willing to draw the line somewhere. So that's a somewhat hopeful sign. But the other hopeful sign is what is happening at the federal level. President Biden has nominated and confirmed more judges and a great diversity of a group of judges in his first year or so than any other president in history. It's been incredible. I had the great pleasure yesterday of attending part of the confirmation hearing in person for Judge Ketanji Brown Jackson. And I think she's still on the hot seat right now at this minute, and will be for another day before others come to testify as well on Thursday. So I see what's happening there as a sign for hope for the future. Of course, her confirmation would not change the 6-3 ideological balance on the court, which is a supermajority of ideological conservatives, but hopefully she will serve for decades, and hopefully she will be joined by other jurists who, regardless of how liberal or progressive they are at least willing to take an honest read on the law and not come in with a predetermined agenda. There's a final reason that I think we are to be hopeful. There's so many things that I said that are battles that seem like we've never stopped fighting, battles from the 60s to today. But there's one thing that we had in the 60s that I hope is starting to reemerge, and that is a moral clarity. The notion that there is right and that there is wrong, that there's up and there's down, there's left and there's right. In an environment in which facts sometimes don't matter at all to what people know, we have to go harder. We can't just focus on communications and telling people information they need to know. We have to get at the heart of what people actually believe. Beliefs about what democracy means, beliefs about who deserves to vote, who deserves opportunity in higher education and K through 12, what is truthful curriculum in the first place, beliefs about who's worthy of a second chance, beliefs about who deserves our care and our empathy, not just from, again, not being attacked by private citizens or police, but our deserving of our worthy of our empathy when it comes to recompense, when it comes to being made whole, when it comes to being cared for in the wake of such violence and such attacks. So with all the things that are going on, I do believe that people realize something is not quite right. I'm emboldened and buoyed by the people who hit the streets over the last couple of years in peaceful protest. My office at the Lawyers Committee is around the corner from Black Lives Matter Plaza in DC, and I walk or drive past it pretty much every weekday. And it's a constant reminder that people are not going to be silent all the time, that people are willing to speak up, an intergenerational or multiracial group willing to speak up for truth, for justice, and the notion that democracy should be real for everyone. I want to end here just to make sure we save time for some Q&A, but I thank you for listening. And if you take nothing else away from today's conversation, think about what democracy means for you, not just in the context of voting, but in the context of opportunity, in the context of being able to move forward in life, in the context of being able to be free and make choices. Think about what democracy means for you and make sure you dedicate your life, your future, whether you're in private practice, working for government, or doing civil rights work, where I hope you join me, that you actually dedicate some of your life and your practice to making the promise of democracy real for everyone in this country. Thank you very much.
Wonderful. Thank you very much, Mr. Hewitt, for those remarks. Powerful remarks, which I know we all appreciated. I have a number of questions, and I've got some questions coming in, but just to remind people that you can use the Q&A function if you'd like to put forth a question. The first question I have here is, where should efforts be focused for future attorneys? Do you think that the focus should be on ground level advocacy? Should it be on lobbying for the election of candidates? Just strategically, what would you advise law students about, how they should best use their time?
Sure. Well, in the nonpartisan context, and we're a nonpartisan organization at the Lawyers Committee, I'll start there and then talk about a different context maybe in a sec. But I think about, I don't know how many people out there are, love hip hop, not just the music, but the culture. But I think about the elements of hip hop. I think about how you have the MC, the rapper, you have the dancers, the B-boys and B-girls, you have the DJs who spin the music, you have the graffiti artists, but the visual artists. All of those components make up the beautiful thing we know as hip hop culture. And I think, for racial justice advocacy, you need quite the same. We actually have to work on multiple fronts. And I think it's really for an individual, it's about matching your interests and your skill sets. What do you want to do every day? I just hired a young man who will be joining our, he's maybe not that young, but young to me, be joining our staff shortly in a few weeks. And he's been litigating voting rights cases. And he said, you know what, Damon, Mr. Hewitt, I want to do policy now. And I said, are you sure? Do you want to kind of lay down your binder at the podium and do something a little different? He said, yes, because I want to be well-rounded. And I love that, right? Not every modality is for everyone, but giving them a try, I think, is important, but also working in concert, right? Those elements of hip hop I mentioned only matter together because they work in concert, right? Sometimes literally in a concert, right? And so I think it's very important to try to have some degree of coordination and alignment. I will also say, again, we're a nonpartisan organization, but on the straight political side, I do think that this false equivalence of the interest of communities of color with the Democratic Party is troubling. I'm not, some, self-avowed Republican or libertarian or anything of that sort, but I also realize that the interests of a party are not the same as the interests of a people. And so I think it's important that we not abdicate our responsibility as nonpartisan advocates and think that the democratic political infrastructure or any infrastructure has it covered, right? I would say the same for the Republican infrastructure when it comes to the Latinx population, where the Republicans seem to be gaining a lot of ground in recent years against all odds, right? So don't have that false equivalence. And I will also say that, the local offices matter. The school boards that are also under attack, school board members, just like election workers are being harassed and under attack, right, by these anti-democratic forces. Those are important offices to hold. And I worry about the people who are leaving those kind of offices in droves, even big city mayors, right? Keisha Lance Bottoms in Atlanta being, almost driven out by the pandemic stresses, of course, but also by the intense degree of polarization. I worry about that. So don't give that stuff up, right? Don't give up that ground. Those are important places to play as well.
Great. I have a question about the Supreme Court in this story. You talked about how it's been hostile, it's fair to say, I think, to voting rights in recent years, whether the Shelby County case or last year's Brnovich decision. Wondering if that's led you at the Lawyers Committee to have conversations focused on litigating in state courts as an alternative. You mentioned the federal courts are changing, but it's going to take time. And I wonder if, the conversation has shifted to focus on maybe state courts as the place to go.
It's a modality that we take seriously. I think whoever asked that's a great question. We in the Texas voter suppression case, we filed in the state court. I think I mentioned it during our talk. And we want to send a message that you're violating your own state's laws. You're hurting democracy. And it also, just so happens that other organizations, I think, filed maybe, a few hours or a day or so before we did in federal court. And you say, look, we're going to try another lane here, right? Because that lane is covered to some extent. So I think it's important we don't give up those state courts. And frankly, as a matter of potential damage control, you're not going to make bad law for a whole circuit if there's a negative ruling. But on the flip side, you don't get positive precedent for an entire circuit as well. So there are a lot of strategic considerations there. And look, not all states are equal, just like not all federal district courts or circuits are equal. We don't just respond to every single incident that we see and hear about. We try to leverage the ones where you can really make some headway, where you can actually tell a story about what's happening. There's an exemplar of what's happening around the country. So we are selective as cause lawyers, even though we do strive to work closely in hand to meet the legal needs of communities.
Great. So you talked about race undergirding a lot of inequality in the country, not just in voting, but in employment and healthcare, and that being a through line, right, that connects past and present. Do you have any concerns, or does it give you pause at all about foregrounding race and whether or not you can get people on board with some of these initiatives when race is kind of described as, the primary variable, you might say?
Sure. Yeah, that's a great question. Well, there is a school of thought and strategy, and even in implicit bias theory about leading with not just race, but leading with disparity, right? Actually can undermine your cause and cause folks to just focus on disparity and have kind of a deficit-based analysis instead of an asset-based analysis. And that's why, we lead a little different. We lead with democracy, right? We're making the promises of democracy real. And we're focusing, of course, on Black people and other people of color, but it's about the core principles and ideals of this nation. Within that context, we speak about race, because when you throw out the facts, and I don't know how it hit with you in the audience, but that as long as there's been elections, there's been racial discrimination in voting. As long as there's been education, there's been racial discrimination and education of various sorts. And that's proven by all of the multitude of court cases and the statutes, right, designed to prevent those things from happening. Those are just facts that are, people can debate individual instances, but it's hard to, debate the big deluge of all of these matters that have happened. So we are doing what I think Lonnie Guinier, late Lonnie Guinier, who was a mentor, and I wasn't her student, but I worked for her for a little bit as a student, as a research assistant her last year at Penn Law School, which she would talk about the minus canary, that you look at the experience of people who are marginalized by society as an example of what can happen to everyone if we don't get some things right, right? So that's one starting place. Another starting place is the high-minded talk of, democracy and what does it take to get things right, but look how it's not going right. So I do think that we can't shy away from talking about not just race, but racism, I'd say, Professor Sellers. I think it's critically important, but we have to contextualize it for people, because otherwise some people just get very defensive about it. We met with, over the last couple of years, a number of Republican senators often from southern states. And one of the chief things they had to say about the pre-clearance requirement of the Voting Rights Act and why they would have trouble supporting it. And in fact, only one has said they would and then shied away after Minority Leader McConnell drew a line in the sand and said, you can't. The number one reason is they said, don't call my state racist. Nobody wants to be labeled as racist, right? Just like nobody wants to be, labeled as being aligned with Nazis or other horrific factions such as that, right? And so it's a hot button thing, and I truly appreciate the spirit of the question. And that's why we try to lead with, look, this is what democracy should look like. Make it easier for people to vote instead of making it harder for them to vote. Can we agree? And then we kind of use a deposition technique and funnel from there, right? Kind of cabin the witness, so to speak, into the place where you want them to be. And it isn't always effective, but you got to find some common ground first, right? You don't go in and beat people over the head. You have to find some common ground, principles on which we can all agree. Because again, we're not trying to tear things down, we're trying to build. And if you're going to build, you have to lay bricks, not throw bricks. So that's how we approach things.
Thank you. Okay, a question about how you understand the relationship between cause lawyering or the work you do and action in the street. You've talked about different modalities and that, these fights need to be happening on different fronts.
Yeah.
But a lot of people, as you know, when they think back to the 60s, there's a kind of debate that exists, right? Well, the work that was happening in the courts was essential, and then others say, no, it was the work in the streets that actually pushed people to change. So how do you understand that relationship?
That's real. That's a great question. So the work in the streets is one of the things that generates the moral clarity. At least when the work in the streets means you're being beaten on Bloody Sunday, as we were just in Selma to commemorate the 57th anniversary just a few weeks ago of the march across the Edmund Pettus Bridge. We're happy to be there, as VP Harris and others were there as well. When you see images of Black people, especially teenagers, being hosed down with fire hoses and having police dogs sicked on them, or when you sadly see the murders, the killings, the 4 Black girls, at 16th Street Baptist Church in Birmingham, Alabama, that also happened, I believe, in '63 as well. So, I think the action in the streets creates moral clarity, especially, sadly, the more tragic it is. It also does something else that's important that I should have listed as one of my sources of hope, is that all the activism around George Floyd and Breonna Taylor and others who were killed by state violence, and Trayvon Martin and Ahmaud Arbery, who were killed by racist hate violence, haven't changed the fact that people are still being killed, but it has shifted public discourse to a degree. It has shifted narratives. People are more willing to embrace a skepticism about police misconduct or police conduct these days, right? More willing to embrace that, hey, things should change, that some of this stuff has to be wrong. We keep getting it wrong. So that's important, right? But to the heart of your question, I do think there was never a smooth relationship between people who were protesting and the lawyers. You know, back in the day when it was only the NAACP Legal Defense Fund plus a lot of local lawyers around the country, that wasn't smooth. That was that was complicated and challenging. You know, I've heard some of the stories. You get the phone call, they got arrested again. They didn't wait for us. We didn't have the plan. But then also I know that my colleagues at LDF, where I used to work, were in the room when the successful portion of the Montgomery March was planned, right? So I think there can be an alignment and a strategy there. It's not just, oh, I got arrested, bail me out, or I have a case. You know, we at the Lawyers Committee this summer, when it was clear that the legislative effort on the Voting Rights Act reauthorization was stalling, we joined other organizations that move bodies and move bases, like the National Coalition on Black Civic Participation, the NAACP, and others. We called it Democracy Summer at our organization. We would deploy our lawyers and our other staff to attend the protests where all of these individuals, including some members of Congress, were engaged in civil disobedience, peaceful protests, and we made sure they were processed and pulled out. We were aligned and we were, planned and strategic, right? Now, I don't know if it generated the kind of, moral clarity we wanted to see, but it's something we certainly were willing to try and had to try. But the important thing is, again, just like the elements of hip hop, like I talked about, there has to be some working in collaboration, if not in close concert.
Wonderful. Okay, I have one more question as we approach time. So with the work that you do, and I would include, public defenders as well, this work can cause despondency in people. It can be hard, I think, to negotiate a healthy work-life balance when you're committed to this full time. So I just wondered if you had suggestions in your personal life for how you deal with that and how you find kind of harmony, given what you have to deal with day to day.
It is challenging. I have a great partner and 3 young kids, ages 2, 4, and 6. So the deuces are wild in my house, and every day is an adventure. I will say this though, as an individual, I tell our staff all the time, it's important to find joy in the struggle. Even there's days when I'm frustrated or, tough to get things moving or get some traction on the policy or legal matter, I still find time to have a human touch and engage with somebody on our staff, some people on our staff, have a laugh, have that personal touch. Because at the end of the day, you're going to go home and hopefully go to sleep, and have a roof over your head and deal with life's other challenges and problems, right? Because there are many beyond the work that we do every day. So I just think kind of maintaining those connections to other realities and is important. But the camaraderie among us is what always drew me to this work, since my days in college. That's why I joined the campus NAACP chapter, because I wanted to be around, other folks, not for a party necessarily, but just for kind of like-mindedness, for conversation, to learn new things and new ideas. That camaraderie continues to sustain me. It's been one of the great blessings of my professional career, is that some of my coworkers, many of my coworkers, have actually become my friends. So I appreciate that.
Well, we're incredibly grateful that you could take the time to join us. And I know that we all benefited immensely from your insightful remarks. So thank you very much.
Well, thank you. It's been a pleasure. Again, I wish I was with you in person, but happy to come back another time and listen to another lecturer and just be part of the audience.
Great.
All right.
Well, we would love to have you, and thank you so much again for those amazing, motivating, inspiring remarks. We are so grateful for your time, your wisdom, your talent, the work you're doing to make our lives better, to make everyone's lives better, and to improve our society and bend that moral arc towards justice, as Dr. King said. Thank you to everyone for joining us today, and thank you to our staff for helping to make this event possible. I hope you all have a wonderful day and make democracy real in 2022, as Mr. Hewitt has just admonished us to do. So thank you, everybody. Have a great day.